So first of all, welcome everybody. Sorry, your evening, of course, Jeremy. Welcome everybody, and thank you for coming back to our fourth session for our workshop on environmental law's extinction problem. For those of you that aren't in Australia, we like to start our sessions with an acknowledgement of country. So I'd like to acknowledge the traditional owners of our great island home. Despite being online, we are also situated on physical spaces. I'm currently on Turrbal and Yagara land, and I'd like to acknowledge that. We continue to walk in the first footprints of Aboriginal people, no matter where we are on this land. By performing this important protocol, I am continuing an ancient cultural practice, and I would like to respectfully acknowledge all elders and officially welcome everybody to this session. So we have a lovely session, and I've had the privilege of reading the three papers that are about to be presented in this session, and they are all wonderful, and I'm very excited to hear the presentation. So with that in mind, we might get started with Jeremy. Jeremy is the Beamer Schneider Professor in Ethics, I think that's what it's called, Jeremy, at Case Western Reserve University. And my understanding is that the role was created to develop undergraduate character and judgment, and it has very interesting ethics and philosophy courses for undergrads. I've been doing some research, Jeremy, including something that I would love to do, an interdisciplinary course on the history and philosophy of science, which just sounds absolutely fabulous. He is a senior research fellow of the Earth System Governance Project, and his work focuses on the human development and capability approach and its potential for multi-species justice. His most recent monograph was published this year, and it's called, I hope I get this one right, it's called Involving Anthroponymy in the Anthropocene on Decoloniality. And his other works include the 2006 book, The Ecological Life, Discovering Citizenship and a Sense of Humanity, and the 2012 co-edited Ethical Adaptation to Climate Change, Human Virtues of the Future. Importantly, for our purposes, he is the lead author of the Oxford Handbook of Environmental Ethics article on anthropogenic mass extinction. Also, after some internet sleuthing, although he's already mentioned it, so it's not really private news anymore, but it appears that he collaborates with his partner, the painter and printmaker, Misty Morrison, and I would love to see some of those collaborations. That sounds absolutely amazing. So without further ado, I'll hand over to you, Jeremy, and thank you very much.
Oh my gosh, thank you, Katie. Maybe if we talk about Wonder later in the discussion, I'll tell you a little bit about what Misty and I are doing for the next book I'm working on, which is on Wonder. So also I like to, it's not standard practice in the highly imperial United States to give a land acknowledgement, but I do give land acknowledgements. So I'm also going to do that for my space. Where I live is a slightly more complicated place because there's not a historical people or nation directly associated with the place in terms of any land claims or any sovereignty. So anyways, I'll read what I normally do. So Case Western Reserve University resides on the ancestral lands of the Lenape, the Delaware, the Haudenosaunee Confederacy, the Shawnee, the Wyandot Miami, the Ottawa, the Potawatomi, and the other Great Lakes tribes, the Chippewa, the Kickapoo, the Waya, the Pinakashaw, and the Kaskaskia. This land of the quote-unquote Northwest Territory was ceded under force from the US military by 1,100 chiefs and warriors signing the 1795 Treaty of Greenville. Subsequently, the treaty wasn't honored by the United States of America, just as all 374 treaties with Native Americans ratified by the US Senate have not been. Today, there are nearly 28,000 Native American people who live in Northeast Ohio, neighbors, co-workers, classmates, and community members who represent over 100 tribal nations. All right, so what I'm gonna do, rather than give a PowerPoint, is I wanna speak fairly conversationally and as if we're in a workshop together. And so the first thing I'm gonna do is send you a link to the paper. It's not the final version of the paper, but it's the version that I have currently of the paper that will be coming out in the law review. Please feel free to take a look at it and to scan along as I'm chatting for this, 10 to 15 minutes more. And by all means, please have a look at it. And if you have comments or questions that you'd like to send my way after this, please do. I'd love to hear from you. So what I'd like to do is, I'm going to read a couple sections of the paper if I have time. But what I mainly want to do is explain the paper as if it was a fabric, say a sweater, that has an ornate design on the front. And instead you turn the sweater inside out in order to kind of see how things were done. And so I want to just explain the paper in terms of what I think was really going on in the creation of it. And then, if you want to find more out about the paper, there it is, you can look at it. So I guess the first thing to say, but what I will do just to situate it is I'll read a little bit from the introduction just so you have a sense of the tone of the paper. And then I'll, like I said, I'll kind of explain it from the inside out. So the paper starts with a quote from Shiri Pasternak, the critical legal theorist who lives on Haudenosaunee land in Toronto. And she worked with the Algonquins of Barrier Lake in this really wonderful, incredibly meticulous and pretty righteous book called Grounded Authority. And she says the Algonquins were less against the state than they were driven by a responsibility to the land, to all the living things and waterways and impacted watersheds. In many ways, this paper is a reflection on the importance of what's contained in that statement. So the introduction starts like this. It says, much of the current order of life on Earth is dying. The central premise of this essay is that much of what leaves us open to mass extinction and drives its approach can be traced back to what is called coloniality. I then give a brief citation of that term. To respond morally to the threat of mass extinction thus demands decolonial work. And this is a matter of prudence. Much indigenous law involves good relationships with the order of life, or as I will simply say, with quote unquote lands, which include waters and airs and skies. While much of the Earth's order of life is dying, we all have much to learn from indigenous law that involves good relationships with the land. Accordingly, we should support decolonizing lands so that indigenous nations may have sovereignty to live by their own laws, and we should support decolonizing laws so that indigenous law may regain jurisdiction. And then I say a little bit about the breadth of decolonization, but I'll just point to one thing here. Most importantly, for the purposes of our context, decolonization involves relinquishing jurisdiction. But that is not all, since there must be translation between jurisdictions when formerly colonizing nation states come to recognize indigenous sovereignty and must forthwith relate justly to it, merging law at the boundary and for interwoven matters. Here is where decolonizing the practice of law comes in. As Anishinaabe legal scholar Aaron Mills suggests, part of decolonizing law is relating personally to indigenous law for its moral insight and authority, moving down the stream of life alongside it, which is an allusion to one of his articles and to an important treaty. This is problematic and strange for professional lawyers working within nation states where duties of fiduciary responsibility to the client obtain. The lawyer's personal view should have little to nothing to do with practicing good law, yet because of its fundamentally philosophical nature and because philosophy demands personal engagement, one can scarcely learn from indigenous law without making normative room for it and personally relating to it, seeking to understand its underlying quote unquote constitution in matters the European tradition would actually call philosophical. So matters of justice that come from the evident right of oppressed people to achieve self-determination and dignity are, in this case, also matters of prudence that reach into our philosophical core, that is, who we take ourselves to be and where we assume that we live. So the paper ends up with a commentary on law. So that said, let me just say a little bit about the kind of background structure of the paper. In many ways, the paper began in 2018 in Utrecht at an Earth System Governance Conference, where in listening to John Dryzek and Jonathan Pickering talk about their Politics of the Anthropocene book, I was struck by Dryzek's concept of ecological reflexivity that he'd written about earlier. And it struck me that ecological reflexivity, which I'll talk about in just a second, was something that was really, really clearly understood and internalized in the roles and responsibilities of some of the indigenous societies that I had been learning up from. And I remember emailing Dryzek afterwards and saying, you know, have you thought about this? Have you thought about the idea that indigenous relationships to lands in many indigenous societies around the world are basically highly articulated, ceremonial, customary, and legal ways of stitching ecological reflexivity into the entire fabric of society? And he said, no, I hadn't, but I'll take that point. That point sounds really important. And it stayed with me. So in this paper, deep in the paper on page 16, I do actually talk about ecological reflexivity. It's one of the premises for my argument for why it's a matter not just of justice, but also of prudence to learn from indigenous nations that can practice their own jurisdiction in relationship to the lands that they're stewards of. And so ecological reflexivity, as I break it down, is it involves at least two things. One, that society must have a way to read or hear the land, that is, to receive feedback from it. That's the ecological part. And two, that society must have a way to stop and take stock of how it's faring in relationship to the feedback it gets, and if need be, to adapt and change as a result. And that's the reflexivity part. And so that concept of ecological reflexivity got me thinking in particular of a concept that Kyle Powys-White, who's a member of the Potawatomi Nation, was writing about in an article from 2018 that I like a great deal. It's called Settler Colonialism, Ecology, and Justice, I believe. I may have missed one of the words. And in that article, White advances a concept he's been developing across a couple different areas called collective continuance. There's a lot to say about what Kyle seems to mean by collective and continuance. But the basic idea is that he points out that in many indigenous societies that have ecological reflexivity stitched into the very fabric of kind of all the different kinds of conventions in society, that there's a high degree of collective continuance, the ability of the collective community, which includes the more than human world, to continue it in perpetuity over time and to modify itself. So we might think of that as sustainability. For various reasons, Kyle wants to call it collective continuance. And then the point is that settler colonial society, and he's focusing particular on the United States, which is, as you know, quite a brutal place, has a very low degree of collective continuance and tends to have structures built into it that make it extremely hard for the society to work as a collective and to continue over time in ways that are resilient and frankly good for everyone involved. And so it struck me, in addition, that when I was looking at thinking about Kyle's work, that for Kyle, one of the things that makes collective continuance work to a high degree is that one's relationships to the land are moral, non-instrumental. And this was the point where I remembered something that I'd argued in the Ecological Life in the early 2000s, when in that paper, in that book, I won't go through all the different layers of argument, but I started to kind of build out actually a fairly ecocentric philosophy from conventional assumptions about common humanity found in the human rights tradition. And one of the first layers of argument had to do with prudence and the importance of environmental responsibility for human self-interest. And one of the points I came to in that chapter was that actually having moral relations with the more than human world is prudent at the level of the collective. So there's a kind of two-stage argument that's common in virtue ethics. And so I realized that Kyle was saying something that I'd thought about and seen before, and that was very important. Okay, so the basic idea, because I don't have too many more minutes, I don't want to take up too much time, is I started looking into indigenous law, and particularly the work that really struck me. Pasternak's I mentioned, but actually someone who's part of her community in Toronto is the legal scholar at Osgoode Hall at York University. André Boissel is her name. And she has done really in-depth ethnographic work with the Stolo people over in the western coast of Canada and the Coast Salish peoples area. And in looking at Boissel's work on the Stolo, which is a dissertation that hasn't been published as a book yet, but it's on what she calls legal sensibility. I was struck by the fact that what is called indigenous law, and then I went back and looked at it in Pasternak and in Mills, really is basically a highly articulated, what I would say from my Eurocentric training is a highly articulated moral political philosophy, where the moral and the political are in a continuum, and governance is woven in to what people who've been shaped by liberalism think of as the moral and personal dimension of life. And so that was the moment where I started to realize that indigenous law actually situates one to have this high degree of collective continuance, in particular by making governance moral all the way down from the major institutions of society all the way down into the most personal parts of people's lives. And so that was basically the thing I aimed for in this paper, that it's in a world in which mass extinction is driven by the dominant social, political, and ecological processes that are part of the long unwinding of European imperialism, so capitalism, industrialism, globalization, that supporting decolonization of sovereignty and supporting the jurisdiction of indigenous peoples who have ecologically reflexive indigenous law relations with their lands is something that everybody in this kind of twisted world should be learning from, because it opens up the space for us to see what a high degree of collective continuance looks like, in particular when law is understood in this way that goes all the way down into the moral. So I don't have many more minutes. I'm gonna just point out, but if you look at the paper, the last section of the entire paper then turns to, after a number of these very big picture points, it turns to the question of what it would be to be a lawyer, so to speak, in the broad European tradition, where law is external to society, and where lawyers have their own distinct role, rather than law being a part of every custom and kind of customary relationship. And so what would it be for a lawyer who's trained in this quote unquote Western way to try to take seriously decolonizing jurisdiction, not just in actually supporting the return of sovereignty to indigenous peoples, but also thinking about what it is to relate across legal systems. And yeah, so I'll do that. Now, the only last thing I'll mention, I didn't talk about it, but central to the paper is a concept I developed in the book that Katie mentioned that I published earlier this year, which is called land abstraction. And so maybe one of the missing premises we could talk about is why I try to show that the various social, economic, and political processes that are part of the long unwinding of European imperialism and that drive mass extinction are the one thing they have in common is they are predicated off of something I call land abstraction. And the thing about land abstraction is that it renders lands instrumental. And so again, once again, the indigenous laws, indigenous societies that have more high degree of collective continuance and moral relationship with the land look like they're in a very good position to teach everybody about what it would be to transform society so that we're not being driven by this wanton land abstraction. So thank you for listening.
Thank you so much for that talk, Jeremy. There were so many things running through my mind as you were talking, but I think front and foremost was the links to the discussions we had last night about instrumentality and how actually it might not just be a subtle movement to move away from that, but this process of decolonisation of lands and sovereignty and law is something that needs to happen to completely transform the way that we view the world. And I think that's really special and something that we all do already consider to be embedded into our perspectives, but to hear it put that way was really fantastic. So I might open up the floor to anyone. We have a few minutes for questions for Jeremy. So if anyone has any questions, you can put it into the chat box and I'll read it out, or just turn your mic off and have a go.
I can have a go first if no one else is before me.
Go for it, Glenn.
Thank you very much for that paper. It's very stimulating, and there are so many ideas that flow out of it that my own thinking connects to. And one of the things that I'm trying to do is work out how good concepts get corrupted by evil people. And so I was thinking about that with respect to collective continuance, and how the CEOs of multinational corporations would just love that idea, because it's shareholders, systems of superannuation, and a whole lot of networks bind people together so that these entities continue, despite the fact that we would define them as unsustainable or in some way perversely resilient. So I was wondering if you have thought about how these concepts, although initially seeming to be opposing the very things that I guess we're talking about decolonialism, how they could end up being used to support it, and that worries me.
Yeah, I mean, this is the thing to say about decolonization, right? It's not a metaphor, but the tendency is to the tendency in capitalism in particular is to try to turn it into a metaphor. And even well-meaning, let's say well-meaning white settlers like myself, right, can use it as a form of virtue signaling. We can use it as a way to aggrandize our research and teaching. There's all sorts of openings for corruption of these kinds of concepts, and yet they're morally necessary, actually, in the strong sense in which Elizabeth Anscombe would talk about moral obligation and stopping modals. In other words, things we must do. I mean, when people are being oppressed, they have a right of self-determination, period. And so, so it's really, I agree with you, it's really hard. So I guess the only thing I would say is that, there's so much to say that I may not have said it clearly enough, but the thing that struck me most about Kyle's work on collective continuance is that moral relations are central to it. And one of the things, actually, I'd love to talk with him more about this and push him on it. One of the things I think he needs to show is how settler societies with what he calls a low degree of collective continuance deal with the fact that they really don't have fundamentally secure moral relations. He'll often say things like settler colonial relations are inherently unstable. So he's aware of this. But there's a really interesting question about how settler societies deal with the fact that they're in moral conflict all the time, while actually still using moral language in certain parts in order to get by. But the one good thing about his emphasis on moral relations is that it gives someone with a concern like yours a place to start, because there's something fundamental about moral accountability, and there's something fundamental about consideration of living beings. I mean, we could talk about this, but I actually have a weird, maybe it's a naive, but I have a very strong view that I actually got by reading the weird French philosopher Jacques Rancière. I don't tend to like French philosophy, but I like Jacques Rancière's work. And he's a kind of radical egalitarian. And one of the things that he just keeps insisting on and pointing to in his work is that, look, I mean, yes, we can misunderstand each other as people, but if you spend enough time with people, you get to know if they're trying to be accountable and considerate of you. And although that's an empirical claim, it's been one that I found in the countries I've worked in and in my life. And so I think that one of the things to do is not just to stay in the realm of theory and the realm of words, but to stay in our bodies and in our relationships, and to understand, like, when are people actually being accountable and considerate, and when is it just bullshit? And that fundamental thing, which is not something one can have absolutely and intellectually, one has to work at it. And most importantly, a community carries you in having that. Practices carry us in having that. That fundamental orientation, I think, is the kind of thing that one needs to kind of resist the tendencies to abstraction and manipulation and exploitation that you're talking about. So that'd be my way of doing it. Like I always, and so the other thing I didn't mention is that the other thing that's big in the paper, in the background, and even bigger in the book, and even bigger in the research, I'll drop links after I'm done, is I'm really interested in what's called relational reason. So everyone uses the word relations now. So I wish I had a different word. A different word might be interpersonal reason, but then people get hung up on the person. But the logical point is this: in philosophy, there's a long tradition of talking about theoretical and practical reason, knowledge that and know-how. But we know in epistemology that there's a very clear other kind of knowing, which is knowing by acquaintance, or knowing what's called personal acquaintance. It's what happens when you're in touch with another person or another persona. And there's an entire logic to knowing that is about relational reason. And probably my big, if I had a big life project in philosophy, which I think is a little questionable, it's a gimmick a lot of times. And I think gimmicks are part of capitalism. But what I'm most driven by is the attempt to try to see what it would be to do philosophy and do a lot of things by taking personal acquaintance really, really seriously. And one of the things that really connected with me when I started to learn up from indigenous people in my country was that this was basic to the practices of the indigenous people in my country. And it blew my mind. And it not something I can entirely do because I'm not in those traditions, but it reminded me of things that I most cared about in my family, in my community. And so that's the other thing. I think we have to be rooted in interpersonal or relational reason in order to be able to resist some of the things that you're talking about.
Thank you, Jeremy. That was a lot to take in, and so many things
Sorry.
to think about. No, don't be sorry. It was wonderful. I am going to throw over to Cassandra McLaughlin, who has a question for you. But we only have a couple of minutes left, so hopefully we can keep that in mind. All yours.
I'll try to keep that in mind. Thank you, Katie. Sorry, can everybody hear me? My microphone may not be the best. Cool. So yeah, I think that Glenn made like a really good point about like the slavering jowls of CEOs kind of piquing their interest at the idea of collective consciousness. Collective continuance. But it just but when I first heard it, it kind of and I might probably need to go and do a bit of reading myself. So if I could be cheeky and kind of ask you, Jeremy, to kind of give me like a bit of what you would say that differentiates collective continuous from like the idea of intergenerational justice, because that's what I kind of sort of vibed that it was more akin to, because this kind of embodied justice, this kind of relational reasoning, this seems to be something that there's a paucity of, there's a dearth of in kind of like everyday legal practice. And yeah.
So I think that intergenerational justice is one of the core concepts of a high degree of collective continuance. So I think what you're talking about would be seen by White, if I understand it. Certainly I've heard Christine Winter say this at University of Sydney about Maori worldviews. But it's necessary for a high degree of collective continuance. So I think you're right on the point. Interestingly, I'll just say this about relational reason for myself. One of the things that's been hard as someone who has grown up in in a Eurocentric worldview and as a white male settler, I do think the gendering is important here, is that it's been very hard for me to try to understand the ancestrality, or if that's too much of jargon, like the idea of spiral time or of circular time or of layerings of ancestors and people. that's something that's really hard for someone from my cultural upbringing to get. And it's also really hard for the way that men are gendered in the United States of America. So yeah, I think what you're saying is right on. And all I would say is that it's also really, really hard for, I think, a lot of people in settler society to articulate it.
Thank you.
Did I answer?
Sorry, thank you. That's really great. I'm going to quickly, very quickly throw over to Philippa, because I know she's been waiting to ask a question before we move on to Erin's presentation.
So this is just a super quick reflection. Jeremy, thank you so much for your talk. I, like Katie, the whole way through was like, wow, this is like building so many connections and challenging so many ideas that I kind of have from my area of research. And I am working a lot in climate adaptation, and this concept of learning is so fundamental to that. And while you were talking though about these sort of two aspects of ecological reflexivity and the idea of listening and sort of getting information about how the land is going, you know, before you decide how you might respond to that. I was reminded of a talk that I heard at a conference in South Africa last year, which is called Species on the Move. And this idea of climate change, kind of redistributing species across the landscape, is raising enormous challenges for knowing and loving and being with country, and this, for, you know, Indigenous peoples as well as for land managers and settler societies as well. But there was an elder there from a Finnish community. His name's Tero Mustonen. He worked with the Snow Change Cooperative. And his community had been given back some really, really degraded land from a mining company, and they had started to restore it to its wetland state. And there was a whole bunch of invasive species, invasive so labelled by, you know, the sort of white law. And he said that the big questions for them, and he'd received permission from the elders to ask, or to tell us what these questions were. The big questions for him were not about, you know, how we manage the land, but they were questions for the new wetland. You are a new person in our community. How do we be with you? What do you want from us? Do you want us to take our hands off and walk away and let you be? Or do you want us to participate with you in a new way of being? And I was sitting at an academic conference, and I was just crying, because I was like, these are questions that I have never asked, you know, and it's a completely different way to think about what we need to know before we make decisions about what we do. I just thought it was so profound, and I wanted to share it. Really, your talk really reminded me of that, the crucial starting point, which is about this idea of acquaintance and relationship and the kinds of questions we need to ask first. So thank you so much. It's really excellent.
You're welcome. Thank you, Philippa.
Wow. Wow, thank you, both of you. That's amazing. I'm so happy that we made time for you, Philippa, because that was a lovely comment. So I do note that Erin had made a comment in the chat box, Jeremy, that also would be useful for you. She said, brilliant presentation, Jeremy. You may have already discovered Mary Graham's work, who many of us in Australian environmental law are familiar with, but if not, you'd find it interesting. So that might be something for you to look into. And on that note, we will move over to Erin. Thank you so much for that, Jeremy. We'll move over to Erin, who actually resonates really well with your work, given the work that she does. Erin O'Donnell is a water law and a policy specialist, focusing on environmental water management, Indigenous water rights, water markets and water governance. She has worked in water resource management since 2002, and she's an early career academic fellow at Melbourne Law School. She has done a lot of research in the groundbreaking new field of legal rights for rivers, and is very prominent in that area, and the challenges and opportunities that rights create for protecting the multiple social, cultural and natural values of rivers. And she's had a look comparatively across Australia, New Zealand, the USA, India, Colombia, and most recently I've had the pleasure of reading her paper on Bangladesh. And Chile, sorry. She has recently completed a consultancy for the World Bank on water markets and their role in water security and sustainable development, which sounds amazing. And in 2018, Erin was appointed to the inaugural Birrarung Council for the Voice of the Yarra River. Erin's latest book, Legal Rights for Rivers, Competition, Collaboration and Water Governance, is available now from Routledge, and you can all go and find that after Erin's presentation. So thank you, Erin, take it away.
you so much, Jeremy. That was such a wonderful opening presentation. And just to follow up on Philippa's comment, I'm here on Wurundjeri country. I can almost see the Birrarung, the Yarra, and it is my privilege to be a member of the council who is now tasked with speaking for the Yarra. And I'm just noticing that I've frozen. Can somebody confirm that I'm actually coming through? Yeah, it's all looking good. Okay, excellent. So yes, firstly, my apologies for the fact that my internet is a little bit crappy today, so I'm going to keep my video off. Yeah, I just really want to echo what Philippa was saying there about the importance of entering into a relationship with the natural world, and the way we as white fellas do it, and I am a non-Indigenous person living Wurundjeri land. We need to very laws are grounded in that sense of morality and relationship to the world around us. Oh, and my internet connection is, I'm going to try and get through this the best I can, so please bear with me. Today I'm going to be talking about the extinction problem that arises when we recognise rivers as living beings, and the way that their rights to law may not have necessarily been reflected by concomitant extensions in water law and environment law. So I'll just go to the next slide. Oh. Michelle, can you move it to the next slide, please? Can anybody hear me?
Yeah, we can hear you, Erin.
Okay, great. Oh,
is it on the right slide for you, Erin?
Yeah, we'll skip that previous one. That was really just saying a reminder of all of the rivers around the world that have been recognised as legal beings. And so this slide, I'm really sorry about the internet tonight, guys. I'll try and soldier on. But this slide is really all about acknowledging the multiple ways that the law recognises rivers as beings. And these multiple legal constructs are all slightly different and bring with them slightly different sets of rights and slightly different kind of legal personas. So just to briefly work through these, because it's important to understand these differences. Legal personhood is where a lot of the attention has been focused. This is the stuff that Christopher Stone was talking about, and the idea that we can recognise in Western law and in common law jurisdictions nature as a legal person with rights of its own, with the ability to go to court, with the ability to enter into contracts. And so legal personhood is a bit of an umbrella term in common law jurisdictions. And it's something that I think is still very largely poorly understood as in terms of what it explicitly conveys. There's a great book that came out last year from Visa Kirky, who does a wonderful historical overview and creates a bit of a new model for legal personhood that tries to separate it out into active legal personhood, where you've got the capacity and competency to go off and take your own actions, and passive legal personhood, where you don't necessarily have all of the capacity, but you still have all of the rights associated with the legal person. So that's the kind of common law jurisdiction ideology behind that. Then we think about the subject of rights. So this is something which was more common in civil law jurisdictions, where there is more flexibility about identifying subjects of rights in law. And to be a subject of rights is a very powerful thing, but it can also be a very limited thing, in the sense that the rights that the subject holds are usually explicitly enumerated. So it doesn't necessarily bring with it other associated rights, which is something that the legal person tends to do. Then we have the idea of the living person. And this is something that we can probably all relate to, because that generally means human beings. So living persons in law it's not really a legal term, but at best it would relate to human beings. And so we have things then like human rights. We start to bring in elements of criminal law. Living persons, can be murdered and are much more akin to what we think of as human beings. And then lastly, we have this idea of the living being or entity, which is a legal way of thinking about and recognising that nature or a river is alive in its holistic sense, but is not necessarily a person and may not necessarily have the rights that we associate with a legal person. So the reason why it's important to see all of these, and look, there are probably more and there are lots of combinations of these, is that they are all used in different ways by the rivers that have received the status in law of a living being or a legal person. So if we just move to the next slide. So these are some examples from around the world in the way that the court or the legislation has defined rivers. So beginning with the Rio Atrato in Colombia, the court recognized it as an entidad sujeto de derechos, which is an entity that is the subject of rights. And those rights were explicitly stated to be protection, conservation, maintenance, and restoration. So here we have that civil law jurisdiction idea of the subject of rights with those explicitly stated rights. The Wanganui River is both an indivisible and living whole. So this is the sort of living being, living entity. And it is also a legal person with all of the rights, powers, duties, and liabilities of a legal person. So we're starting to see this combination of ideas coming through. This was taken to a whole new level with the Gundra and Yamuna rivers, which were defined as juristic, legal persons, living entities, the status of a legal person, and all the rights, duties, and liabilities of a living person. So that's really bringing everything together. They're living beings, they're legal persons, they're living persons, and that sets up some really challenging kind of potential legal outcomes, which I'll get to in a little bit. The Turag and all Bangladesh rivers, which were recognised last year, and sadly I cannot give you the formal words because they are in Bangla and I do not speak Bangla, but the court recognised all rivers as legal persons and living entities. So again, we have this combination of the legal status as well as the recognition in law as a living entity. And if I just move on to the next slide, we'll talk about a couple of Australian examples. So these examples, I think, are really important in the Australian context because to build on what Jeremy was talking about, I want to unsettle the idea that there is one law in Australia. Australian law is very bad at recognising our pluralist jurisdictions. And when we speak about unceded lands and unceded sovereignty that Aboriginal people still maintain, this is what it means. It means that there are multiple systems of law operating within Australia right now and that those systems of law are valid. So the Matawarra Fitzroy River has been recognised in the law, the first law of the native title holders, as a living ancestral being with a right to life. So this legal statement is centering around that living ancestral being concept. Now, the Matawarra Fitzroy has not been formally recognised in settler state law. So we're still kind of waiting to see how that plays out. The Birrarung, the Yarra River, the river and its associated land are recognised in settler state law as one living and integrated natural entity. And one of the reasons why the law does this is because of the involvement of Wurundjeri people in crafting this legislation. Because for them, the river is a living being, it is an ancestral being, it's a being to whom they owe obligations. And so having that formally recognised in law, much as it was important to the Wanganui iwi in Aotearoa, was similarly important to the Wurundjeri Woiwurrung in Australia. So just moving on to the next slide. So this raises some questions about the life and death of rivers in law and how do we recognise these states and how do we understand what death looks like and what does it mean for rivers to go extinct. So in the paper, I work through this in a number of different ways and oh, hang on, where are we going? Back again. So I'd really like to acknowledge the thoughtful and detailed review comments that I've got because it really inspired me to think more closely about this for the purposes of this presentation and for the final paper. But if we just work through some ideas, firstly, rivers are clearly ecological communities. They've been recognised as such in scientific literature for a very long time. Ecological communities are of course at risk of extinction and environmental law has begun to recognise that. But the challenge often is defining those ecological communities to a degree of specificity that actually matches their place and their scale. And we had some fantastic discussion yesterday with Tom about the importance of that scale in trying to understand and define extinction events and species definitions. So the same kind of thinking applies to ecological communities. Rivers are also water dependent, and I'm going to come back to that, but it's an essential component of being a river that there is flow, at least at some time of the year. And water quality and water quantity are both equally important. Rivers are spiritual beings, so that spiritual connection and the maintenance of that spiritual connection is also an important part of their legal recognition as living beings. So it raises questions, I think, about the potential disconnection of that spiritual connection, and what would that be a form of extinction? And certainly within Indigenous legal contexts, yes, it would be a form of death. So what is river death? We've recognised it in informal ways a lot. So probably one of the most prominent examples, if you Google river death, is the idea of the Thames, and when it was declared biologically dead back in the 50s because it was so polluted. But this also brings together the idea of river resurrection. Can rivers be reborn once they have been considered dead? And that sets up, I think, a really dynamic understanding of what extinction represents for ecological communities, for rivers as living beings. And just to tie it back to the definition of rivers in law, the Yamuna River was also declared dead because it's a highly polluted river. All of the rivers that have received this recognition in law as living beings or legal persons are beloved, but highly impacted by human activity, and the Yamuna is one of the most iconic in the sense of being extremely beloved and extremely impacted. So there is a police report on file for the murder of the Yamuna River, and this gets back to the idea of the river as a living person that is then capable of being murdered. So I think recognising rivers in this way creates lots of legal kind of questions around how do we then acknowledge their life and death? How do we bring them into this conversation about extinction? So if I just move to the next slide. This, for me, is one of the most important elements of this discussion, is recognising that for rivers, water is life. And this image shows environmental flows. And it comes from the website of the Victorian Environmental Water Holder. And the purpose of this is showing how different flow levels in the river system are keeping different parts of that ecosystem alive and functional. And you can see, therefore, that multiple types of flow, so diversity in flow is really important. You can see that timing of flow will be really important, because if you get an overbank flow, say at the wrong time to support fish spawning or tree recruitment, then yeah, it may as well not have happened in some ways. So the timing, the frequency, the duration, the volume of the flow, all of these things are incredibly important for rivers. So that connection to water, having some ability to control the water that is inside their banks and sometimes outside their banks, is really important for their life, for their maintenance as living beings. So if we just go to the next slide. How does this play out? And somebody tell me if I'm getting close to time, but how does this play out when we look at the rights and legal rights specifically that have accompanied this recognition of rivers as legal persons or living beings? Water rights is excellent. I've got a good amount of time to go. So water rights are a good place to start, in the sense that no rivers that have been recognised as legal persons or living beings have been formally accompanied by a handover of water rights. So, for instance, the Wanganui, Te Awa Tupua, owns the riverbed, but it does not own any of the water in the river. And in fact, as I'll go on to talk about, there is no change to any of the water rights in the Wanganui system. Now, in that instance, it was fairly deliberate on the part of the Wanganui iwi to exclude water from the treaty dispute settlement that gave rise to this legislation. And that's a strategy that they're pursuing. But that's, for now, we have a river that owns its bed but has no ownership or ability to influence the water flowing within its banks. The Rio Trato similarly has no property rights and no rights to water. None of the others have any rights to water. Even here on the Birrarung, The Victorian Environmental Water Holder does own water rights on the Birrarung River, but the Birrarung Council, the voice of the river, has no role in how those water rights are actually used. And that also means that formally, the Wurundjeri Woiwurrung people have no role in the way those water rights are used. So water rights are definitely part of this conversation, but an essential component is also this role in water management. And this is where things start to get a little bit more hopeful about the future for these rivers and their ability to influence the most important element of remaining alive. So both the Rio Atrato and the Wanganui were accompanied by new institutional arrangements to support the guardians of the rivers. And so those guardians were embedded at the centre of new river management, new catchment management arrangements that sought to protect the river and in fact strengthen the voices of the people who live along and depend on the river, in both cases including Indigenous peoples in the form of the Māori and some of the Indigenous peoples along the Rio Atrato, as well as other communities that live along and within the river catchments. So those I think are hopeful signs that we're starting to try and give the legal person and the living beings the legal supports they need to influence, at the very least, the necessities of their life. Things get a little bit less optimistic when we start looking at some of the other rivers around the world. So the Gundjer and Yamuna, again, it was a court case. That one's basically on hold as it moves through the appeals process. There were no new arrangements to really give effect to changes in river management. I think there was optimism from the court that by nominating guardians for the rivers, that this might drive changes to those institutional arrangements. But as we know, the reason these cases are under appeal currently is that the court-appointed guardians included state government bureaucrats, and they desperately did not want that job, and so they were the reason for the appeal. In the Turag and the rivers in Bangladesh, the court initially recommended, or initially found and directed the government to give the National River Protection Commission the powers that it actually needs to have some kind of control over development along rivers and the way that water is managed in rivers. However, this was then appealed, and the Supreme Court Appellate Division decided that the court does not have the power to direct government to pass new legislation. So that's still a recommendation of the court rather than a binding directive. The NRPC is optimistic that they'll be able to have some kind of increased legal powers, but we're really still waiting to see what they look like. The Marawara, again, is still suffering from its lack of statutory recognition. So within Indigenous law, there is, I think, a growing and very strong basis for river management and catchment management and caring for country. But this has not yet been recognised in any way by the Western Australian government, and so their ability to influence very limited, being made in the short term about potentially massive new water extraction projects to support irrigation in that catchment. Hopefully my internet is going to hang on. Finally, with the Birrarung, the Birrarung legislation, Wilipgin Birrarung Moron, which means keep the Birrarung alive, is really about a new governance model and a new land use decision-making framework for the Yarra and its associated lands. It does not really alter any of the water management arrangements. And so the Birrarung is the source of up to 70% of Melbourne's water, and this inability to influence the way that water is managed poses some significant risks to the ongoing. So moving on to the next slide. So just a problem for rivers and recognising rivers as living beings. Oh, don't, just go back a second. Anyway, recognising rivers as living beings without putting in place the legal measures that they need to play a role in water management has increased their risk of extinction. So I think the question here is, how can environmental law give force and effect to this legal status? By recognising the extinction risk, by actively trying to reduce it. And then we'll go to the final slide, which I feel we've all previewed. So I'm kind of identifying some possible solutions to this extinction problem for rivers. And I think one of the things that environmental law really needs to grapple with is the ability to have a strong place-based focus. And by that, I mean acknowledging the specificity of rivers and their non-substitutability. Protecting one river is not a way of protecting the essence of rivers. So in fact, all rivers need protection, and our relationship is with each river, not with rivers in general. And then I think the other element that environmental law needs to explicitly engage with is the willingness to protect nature. So some of what we can do as lawyers is kind of force the hand of governments to take action and to do things, and we can use the law in that sort of adversarial way. But too much of that and you end up with a legitimacy deficit. So I think centering First Nations and Indigenous peoples, and as Jeremy's already talked about, their, I'm going to forget the phrase, but that beautiful idea of continuous presence and continuous, Jeremy, can you remind me of your phrase? That was just gorgeous, and I'm so sad I've forgotten it.
It's not mine, it's Kyle White. It's collective continuance.
Collective continuance, thank you so much. And I think that resonates with a lot of what I'm hearing and learning from First Nations and Indigenous peoples across Australia as well. And it's a way to connect people and place. So again, we're talking about specificity, and it's a way of building and engendering a reciprocity as the core of our relationship with rivers. And that's where I'll wrap it up. Thank you for bearing with me and my stupid internet.
Thank you so much, Erin. That was so good. I can't believe you're in the middle of Melbourne and you don't have good internet. That's just mind-blowing. I think there's a bit of a lag, so we will try our best with questions. So I'll open up the floor. Does anybody have any questions for Erin? You can put your hand up virtually or just go for it.
Perhaps not a question, but a reflection on both Erin's piece and Jeremy's and Glenn's.
Yeah, it's a mystery to me too.
That. Sorry?
I think that was a very lagged comment about the internet.
Oh, this sense of performing decolonisation, which very much, the Madawara example for me is one that embodies the discussion that occurred beforehand. And I'm reminded of Irene Watson's work, which refers to the colonial project as a muldabi, like this spirit animal that changes shape all the time, pretending to be something when in fact it's not. And I think the Madawara example is a really good example of that, because along the Madawara, First Nations, and it's a range of nations across that river, First Nations have agreed, perhaps since the beginning of time, the relationship between the groups along the river, how they have shared responsibility across the river. And also most of the native title determinations have occurred along the river. And yet there's this lack of being able to perform Indigenous law in the way it should have been done, despite having so-called native title, because that of course doesn't include waters. So just a reflection on how your piece, Erin, draws through perhaps issues that are occurring across the globe, and the need to decolonialize, but the difficulties, the forces that we're up against in attempting to do that.
Yeah, absolutely, Michelle. I think it's one of the really important things to remember about the rivers that have been recognised in this way is that it has, the most successful examples, the longest lasting examples, the ones that have the best institutional settings have come from Indigenous peoples and their leadership in this space, and their hard work and strategic action in pushing settler colonial states to recognise their existing legal frameworks. So I think rivers and their recognition as living beings and legal persons is a way of acknowledging legal pluralism.
We have a really great comment from Jeremy. I don't know if you want to jump on and talk about that, Jeremy, or are you happy just to let Erin read it from the chat box?
Yeah, you don't need to hear more of me. I just wanted to connect. This great presentation. Thanks.
I think we always need to hear more of you. Okay. Sorry, Afshin.
And I would love to. The other thing is because I'm just going to say, because I dropped out, I can't actually see any of the comments that were posted in the chat. So if somebody wants to send me some of those again, that would be great.
I will email them to you, Erin.
Thank you.
We probably have time for one more question. So I think, Afshin, did you have a question?
Yeah, a comment, Erin. And look, despite your internet worked fine, so thank you for that presentation, Erin. And I'm really pleased that we had you exploring concepts of loss, death, and extinction around rivers. It's fantastic. Thank you. One of the things I think that struck me, and I think Jeremy's paper was also similar. I find we sometimes bring capitalism and appropriation into a dialogue when I think they're probably sometimes separate things, because I think everything in life is constantly appropriating. The question is what that appropriation then means in a larger collective context. And I think one of the things that I think that strikes me about your discussions of rights, and I'm not sure if I'm spot on, like whether it's coming across clearly or not, but one of the things that I think law does, whether it's in the allocation of water or giving rights, is it appropriates the way we think about time and what time means for natural systems like the river, because I think a river system functions to a different sense of time. And in that sense, then we are constantly appropriating the river when we try and transcend and impose ourselves on it. And I know it sounds like a really esoteric way of thinking through this, but I guess I'm always thinking about the way we appropriate, because I read Michel Serres, and one of his books is called Malfeasance. And in that book, he begins by giving an example of how a dog, by urinating, is actually appropriating for himself a particular portion of the world. And so appropriation is not just a human way of thinking, it also happens amongst all sorts of other things. So it's a random set of comments, I guess, just to throw into the mix about how, from a river's perspective, things might look quite different, and whether the law is appropriating for whom. But thank you, Erin, for this interesting paper.
Erin, did you want to respond before we move on?
Maybe just quickly, I think your comments about appropriation are really interesting in the sense that I think it's a word that has become loaded with meaning. And I think what we need to keep thinking about with appropriation is the power dynamic. So the dog can appropriate a small part of the world to itself by marking its scent or urinating. When it uses that power to impose its will unilaterally on everything, then that becomes a problematic appropriation. And I think one of the challenges with recognizing rights of nature and rights of rivers and rivers as legal and living beings is to continue to see it in the context from which it has come, and to not co-opt these very specific and place-based responses of law into a particular framing. So I think it's a challenge for environmental law as much as it is for capitalism or anything else, because being aware of why these changes have happened and for what purpose is an important part of that appropriation debate. And I think in some ways, appropriation is a pathway to a much more pluralist way of being, provided that it's done with consent, with free, prior and informed consent, and with power sharing, or at least trying to break down existing power imbalances.
Thanks, Erin. Great response.
Thank you so much for that, Erin. That was really wonderful. Just noting the time, we're running out of time for Paul, so we'll move on to Paul Govind, who's a lecturer at the Macquarie University Law School. Welcome, Paul. His research is focused on the theoretical and practical challenges that environmental law must encounter in adapting to the realities of the Anthropocene. So his current projects include a critical analysis of the resistance of modern environmental law to the epistemic transformations triggered by the Anthropocene. And this year he has been very busy, because not only did he come onto our project at a very late stage and put something together for us very quickly, but he has published a couple of amazing papers, including from Hubris, I never know how to say that word, Hubris to Humility, Addressing Extinction Requires Environmental Law to Fundamentally Revisit How It Sees Itself. And also he has published a paper called Examining Legal Responses to Climate Displacement in the Anthropocene, a Case Study of Bangladesh. So thank you for making time for us, Paul, and take it away.
Thank you, Katie. Thanks everyone again, Afshin, Michelle also. I'll just share the screen. I'll try and change that to slideshow. Yep, everyone can see that? Yep, good. Okay, so my talk today is inspired, I think, by a relatively recent episode in environmental planning law here in New South Wales. Just for full disclosure, I'm a bit of a newcomer to the area of biodiversity law and extinction. A lot of the ideas that I've applied in this research, I've taken from the Anthropocene space and more the climate change adaptation space, and then brought them across to kind of frame my understanding of extinction and the extinction crisis. So I'm coming from that sort of space, but I'm talking today about the importance of responsibility in the context of law and law's adaptation to the Anthropocene in general, but particularly to extinction. So I just want to start here with a couple of key quotes that I've sort of gathered with regards to what responsibility might mean and might look like in the Anthropocene context. So the first one here from Stephen Gardner emphasizes that responsibility and where agents are aware that they contribute by their actions to structural processes that produce social and environmental injustice. And when thinking about the law, environmental law and responsibility, one thing that strikes me is whether or not our legal mechanisms, our legal processes and our institutions and structures are actually aware that their actions are contributing to injustice. The second point here from Vito De Lucia talks more about the Anthropocene itself. And it says, the sort of last bit there, the last sentence, we are not only driving global warming and ecological destruction, we know that we are. And so again, it sort of reinforces this idea that responsibility is premised on this cognizance that we as humanity, and by extension law, understands what our actions are doing in effect. And the last quote here from J. Ellis, talking about responsibility, suggests that in conditions of uncertainty, which of course the Anthropocene is, we need to make a decision, take responsibility for its consequences by compensating those who suffered unintended harm, or by understanding the consequences, and correcting the course. So the idea there is, well, what we need to do is be a little bit more humble, I think, in terms of what we do know about where we are in terms of our relationship with nature. And if indeed we are responsible, we need to ensure that the course of action that we follow to get to that point is not repeated. So through this sort of research, I've developed these 3 criteria. And thankfully, Jeremy's already spoken to the last one there, reflexivity. So I'll just quickly talk about the other 2. Entanglement. Now, entanglement, again, is a strong reflection, I think, of Anthropocene. It talks to this idea that unlike the previous Holocene epoch, where humanity was very much separated from nature, this distinction has collapsed, and we really now inhabit this era of entanglement. And sort of growing from that idea and from the idea of reflexivity is humility. This sort of goes to our understanding of knowledge, and the idea that where perhaps humanity placed some sort of supreme emphasis on its knowledge of nature and its knowledge of its relationship with nature, again, this sort of idea has proven to be redundant. And rather than, I think, double down on sort of processes which elevate our understanding of nature, or our presumed understanding of nature, we need to exercise humility and understand that we are not perhaps in the state where we once were, or even if we probably weren't ever there before, but at least the artifice has to be taken down. And we need to understand that, yeah, we are actually at ground zero with this. We are at point zero. Everything now is going to be new. Everything that we learn is essentially that. It's going to have to be learnt. Now, just building on, before I go further, just to sort of, I think, tie this back to the theme of the session and tie it back to what Erin and Jeremy both said. When I talk about things like learning, and I talk about things like humility, etc., I am talking distinctly about the Western legal model here as well. I just want to make that very, very clear before we go on. Now, I'm going to start with what brought me here to this sort of conversation. And that is this, what I referred to earlier, this incident in New South Wales, this environmental planning episode. And it takes place in basically Western Sydney, in a place called the Blue Mountains. And it deals with this, the Warragamba Dam. Now, the Warragamba Dam is basically the water source that supplies most of Sydney with its usable water. And in recent years, there's been a proposal to raise the wall of the Warragamba Dam. Now, the reasons for this are quite sort of straightforward. Properties in Western Sydney had been flooded, and in order to prevent this, there was a need to raise the dam wall. Now, the assessment and approval process under the legislation you can see there, this was performed in around 2016. However, since then, New South Wales and Australia has experienced the most horrific bushfire season well, possibly in history, in human history. And as a result of that bushfire, there's been mass extinctions. Now, the interesting thing about the Warragamba Dam dispute is that despite this, the occurrence of the bushfire season, despite information that suggests that endangered species are now critically endangered and have moved into refuge areas, the assessment process doesn't seem to think that this information is necessary. So following the bushfire, Commonwealth departments basically said to the New South Wales agency that was responsible, Water New South Wales, you need to do your assessments again, because the areas which are going to be flooded when you raise the wall have become refuges for animals that had to flee the fire. Water New South Wales has basically turned around and said, no, we're not going to do the assessments again. We're going to keep the assessments based on 2016 prior to the fire, and that's the end of the story. Now, in terms of extinction, this is quite an horrendous sort of outcome. As I said, those areas have become refuges for these for many species, including, well, apparently including even koalas. So the sort of move, I suppose, to circumvent this particular information that had been provided by the Commonwealth government seems to, I think, suggest to us that unlike many other episodes of extinction, the information is readily available. The event itself, the trigger event, is particularly clear. And so those can't be used as excuses. So if the law is not going to compel or mandate a reassessment of the extension of the raising of the dam wall, we are only really left with one conclusion, and that's that this is a value decision. And it's a value decision that's based upon those values which are very much embedded in the legislation. So after the cataclysm, do we know what we're actually doing? So the takeaway, as I said, is that these knowledge mechanisms, which have been used as the basis of the assessment, in particular the environmental impact statement, the knowledge mechanisms are sound. It's basically telling us that the knowledge that we have in terms of the immediate area that will be flooded as a result of raising of the dam wall is fine. There's nothing there that we really need to be concerned about. So this sort of made me think, if something as catastrophic in terms of biodiversity loss and extinction, such as the recent bushfires, if these can't trigger a transformative change in our laws, then what can? So it sort of prompted me to think, well, what is the values embedded in our law that are resistant to such a decision? So the key thing for me that really is, I think, at the heart of this issue is that extinction challenges our notions of property in a way that we have not really seen before. Property really lies at the heart of the Western legal model. It's very much at the heart of all environmental planning law as well. Now, what this particular episode of Extinction suggests to me is that in the context of Anthropocene, in the context of mass extinction and climate change, what we are seeing is what we will see from here on into the future is a constant reconfiguration of the boundaries that we share, or the land that we share, with non-human species. Now, this reconfiguration does not resonate with the property values that drive our law. Property is based upon this idea of borders, of certainty, of predictability, etc. Reconfiguration of space in terms of extinction totally goes against that sort of idea. So it brings me to this idea of, well, what knowledge mechanisms are we using, and how can those knowledge mechanisms be used more effectively to imbue a sense of responsibility in our law to non-human species? So I've sort of used this, you can see this quote here from Lorraine Code. Lorraine Code being an ecofeminist who's worked very much in the area of epistemology. Ways of knowing can be judged appropriate partly on the basis of responsibility manifested by cognitive agents in making knowledge claims and acting upon the assumptions that they know. So for me, in terms of reorientating our law towards something which better understands the Anthropocene and the plight of extinction, it's these areas we need to target. Knowledge claims and the assumptions that these are based upon. So, as I said earlier, property really forms, I think, the core in what we're doing here, in what we're doing in this particular space. However, where we will really struggle, where the efficacy of a property-based or property-driven understanding of space will be sorely tested, is the presumption of stability. This presumption no longer applies to our relationship with nature or the planet in the era of Anthropocene. So once this element of stability is removed, we have a real sort of struggle on our hands. How do we reorientate a legal system which is purely, well, not purely, but is primarily based on the idea of stability? How do we reorientate that towards a future of constant reconfiguration of space? So in looking at some of the findings here of the Warragamba Dam issue and how responsibility might give us a slightly different, I suppose, view of what of how to evaluate what has gone on. The first point there is what I've already said. In recovering from a mass extinction event, nature has been reconfigured. The reconfiguration is essential to survival and must be a respected part of any intervention to adapt to the impacts of climate change. Now, this brings me to another interesting point about the Warragamba Dam episode. As I said earlier, the raising of the dam wall is to prevent flooding of homes in Western Sydney. Now, in all the policy documents that ran up to the most recent examination or assessment of the project, climate change adaptation was noted as being something relatively important. Now, the interesting thing here, though, is how the different, how this resonates with property creates a sort of almost a priority list in terms of environmental issues. Climate change adaptation in this context resonates strongly with what planning law is trying to do, because in this case, it's been undertaken to protect property. But the underlying sort of consequence of it is that it will remove the refuge that so many species have now moved into as a result of the bushfires. So this fragmentation of different environmental problems also sort of shows to us the difficulty in resolving this issue using a legal system that is based on property. Now, just moving on to the next point, the failure of the environmental impact statement to properly consider the impacts of inundation shows a complete disregard for the ongoing entanglement of humanity and nature. So even now, there is this division between humanity and nature that is at the heart of this whole dam extension project. The priorities are quite clear. Even in the advent of a flood, the priorities are given to humanity and property over the species that might reside in the flooded area. So what it tells us about the knowledge mechanisms within our law is that they don't serve to educate. They mainly are there to confirm what the project is designed to do. The project design is laid down, and basically all the environmental impact statement, i.e. the knowledge mechanisms in our law are designed to do, is basically ensure that these projects are within the limitations set by law. They're not actually trying to inform us of any change in environment, in ecology, or indeed in the risk of extinction. So going down to the final bullet point there, so the intervention of DOR, that's the Department of Agriculture, Water, Environment for the federal government. The intervention by DOR in terms of the assessment process, and DOR led this, led the claims that the raising of the dam wall would risk extinction. The intervention by DOR really doesn't say anything about legal thresholds. DOR wasn't compelled to do this under any particular law, at least not directly. What they were concerned about simply was the robustness of the information. Their key concern was the methodology that was used by Water New South Wales. Okay, just to move on then. So what I think needs to happen then in this space is, if we are going to use something like planning law in order to avoid extinction, we need to stop looking at the relationship between humanity and nature, humanity and non-species, in terms of property, in terms of boundaries, and change our perspective to space. So this would allow at least a more sensible way, I think, to understand the competing uses of space. It should be, hopefully something of a leveler, because property, of course, in all dimensions is a hierarchical structure. So looking at the issue in terms of space rather than property should ensure that all different uses of space are considered equitably and evenly. Okay, so where do we go from here? Now, in terms of the planning law, you may think it's relatively straightforward. We could say something like, well, all environmental impact statements should include references to extinction. Another way to do it would be to look at all potential activities and characterize or frame them as potential extinction drivers. This would apply to whether something's intentional, unintentional, direct or indirect. The final thought would be attachment of extinction to conditions. So if there's anything that gets approved, such as a dam, there will be conditions attached which says that extinction is an issue which the developer or anyone else has to be mindful of over time. The problem with this, though, of course, is that conditions must be something which the developer or land user can actually achieve. And if they can't achieve this, extinction's a big problem because there's so many multiple drivers. If they can't achieve this, then the condition will be rendered invalid and not of any use. So yeah, just to wrap up quickly, the idea here, the collision really that we've seen in the Warragamba Dam, I think comes down to, can we reimagine our relationship with nature, particularly in terms of extinction, rather than through the property lens? Can we reorientate this into a space lens, whereby the hierarchy of property is removed and we have a more equitable structure for looking at how indeed we need to share land? Okay, thank you.
Thank you very much for that, Paul. That was really insightful and a very current issue that New South Wales is facing at the moment. I do note that we're, only got 1 minute to go until 10:30, and I understand that some other people might have meetings to go to, and that's perfectly fine. But I did want to give an opportunity for questions for Paul. However, I'd like to maybe throw it over to our colleagues in Myanmar, or I know that Jeremy's got some students here that would like to ask questions. So if there's anybody else that would like to comment on Paul's presentation, please do so. Cassandra, you've got your hand up. Would you like to have a go?
Yeah, I'm just assuming that I'm one of the students. Thanks for this semester, Paul. So just talking about kind of moving from like a property sort of frame of mind, sort of like a space frame of mind, and this is going to be kind of a bit of an out there comment. It just reminded me of an opinion piece by Douglas Rushkoff, who is kind of like a futurist writer, and he recounted how he was invited to like a private post-keynote gathering hosted by several unnamed billionaires who all exhibited like the full cognizance of the risk of planetary collapse. And in the little get-together, they quizzed him for his opinion on how to best insulate themselves to what they euphemistically called as the event, like should they require their security guards to wear shock collars. And I'm just very conscious of how deeply this property concept as an idea, as a mode of legal practice, has so thoroughly infiltrated kind of all aspects of kind of modern functioning. And this is not something that we're going to sort of solve today. I'm just very, I guess, contemplative of how to move something that seems so ingrained from one space to another. But I think that the idea of kind of trying to go from property to space is like a really like interesting and a really loaded with like potential. So this is more like a comment than anything. Thanks, Paul.
I'll quickly say something then. Well, I mean, my view on it is that when we look at Anthropocene in particular, and any of the issues that are sort of closely tied, distinct but tied to Anthropocene, such as mass extinction and climate change, we have to really be, I think, aware that what we are doing as a legal response is adapting laws that already exist. And we have to do that at least in the short term until whatever we can do in terms of creating new laws or whatever else. So we will have to deal with this issue. And because these laws were not drafted, don't operate on the value system that we probably hold today. And it's still, all of those laws are particularly anthropocentric, and anything that's anthropocentric is going to be property-centric at the end of the day. Now, that's not to say that all people necessarily benefit from property in the same way. That's kind of the point I was trying to make at the end. Property is extremely hierarchical, and it is something which I think affects our intrahuman relationships, and then also affects our relationship with nature. So yeah, it's deeply embedded in everything that we do. As I said, it's the cornerstone, I think, of the Western legal model. So even with climate change adaptation, I believe that it has an interesting relationship with property, because if adaptation measures interfere with property, the adaptation measure is resisted by property holders. But in a case like this, where adaptation benefits property, it's very much celebrated by property holders. So everything that we do, all interactions with nature at least, is going to be viewed through this lens. How does it interact with property? And one of the problems for extinction is that the drivers of extinction won't be really framed as loss unless that can be translated into a loss that affects property in some way. And that's why I think it really, unfortunately, falls a little bit sort of down the ladder, so to speak, at the moment, because at least with the adaptation question, there was that resonance with property, but extinction, not so much.
Thanks, Paul. I know also Jeremy's put a comment in chat that says, building off Cassandra's comment, one thing to note is that mine own can mean what I own or that to which I belong. This reversal seems crucial to moral accountability and the curtailing of wanton license, which much property law currently allows in commons issues. So thank you. And Philip has also said thank you for your presentation. On the issue of law and climate adaptation for major projects, I wonder whether you have come across the scholarship on adaptive management in law. That scholarship has engaged with the possibility of calling in major projects that have been approved, but where new climate or environmental conditions render the project inappropriate, unviable, or socially unacceptable. And I think that might also go with to issues where the project has extended its reach or breached conditions that aren't currently being followed up on because there's no accountability in environmental law. I think I'll leave those comments with you to think on, Paul, given that we're 5 minutes over time. And I would like everybody to just give our speakers today another round of applause. Thank you so much for attending. And for those of you that can make our final session tonight, where we're going to be hearing from Afshin and from Glenn Albrecht, that will be in about 7 hours, I think. I know it's 6 p.m. my time, but it's in 7 hours. So I'll see you then.
Thank you all.